All right, good afternoon. I'm attorney James Betzold, and we're going to do this one in English now. As you can imagine, we have clients both in English and Spanish, who primarily speak those languages, and sometimes it's just not fair to do one but not the other. So here we are, and we're going to do this is one of our first updates on the video we did about the Biden parole process that was announced yesterday. As you can imagine, we're pretty excited about that because it's really going to help a lot of our clients, clients who are already eligible, who are already in a process to do immigration. It's just going to make their process go a lot faster. A little later, we'll get into some of the details of why this is a great thing, and it's really not a change in the law. It's just using existing law. But first, I want to go over some of the details that are released so we have a little bit better clarification of some of the things we talked about yesterday. So as you can see here, this is coming directly from the government's website, the USCIS website. This is the official administration that takes care of or that decides immigration petitions. And they have an update here. So we're going to go past some of all the nice statistics. First of all, they estimate it's going to help at least 500,000 non-citizen spouses of U.S. citizens and approximately 50,000 non-citizen children of them, which is great. I mean, if you're making life better for 500,000 people, just imagine the human potential behind all that. On the topic of eligibility and the process to go through, we have a couple more details, right? So first of all, to be eligible for this grant of parole, you need to be physically present in the United States. So this isn't for someone outside of the country, only for people who are here already. Along with being physically here, you need to have been here for 10 years. Now, the way that they word it here, as of 10 years, as of June 17, 2024. So later on, they say if you've been here since June 17th of 2014, just to clarify the exact date that they're going to go by, then that is what will count. You also must have a legally valid marriage to a U.S. citizen as of June 17th of this year. So if you have been engaged but didn't get married yet, or were not married as of June 17th of 2024, this program will not help you, at least not yet, unless there's some change to it later on. But those who were married as of that date, great. And that marriage has to be legally valid. So it's unclear, I guess, to be fair, if in that phrase it says have a legally valid marriage to a U.S. citizen as of that date. It doesn't say it has to be on that date. It just says as of. So that would imply any time period beforehand. So will that include people who were married to a citizen but then got divorced? Unclear. Someone in that situation may already benefit from a VAWA case or some other protections. But what we know right now is this. This is what's been published. Okay. In addition, you can't have any disqualifying criminal history. Now, you may ask Attorney Betzold, what does it mean to have a disqualifying criminal history? I can give you some brief outlines. In immigration, there's a lot of vagueness where they're not totally defined great. For example, if you've committed a crime of moral turpitude, that may disqualify you unless you apply for a waiver. So I would have liked them to say here whether it makes you inadmissible or not with or without a waiver, right? Because what's going to disqualify you from getting a visa is if you have a crime of moral turpitude and you don't meet one of the exceptions for it and you don't have a waiver that was granted for it. So this itself, looks like USCIS and those who govern are once again being a little bit vague about what that's going to mean. But from my experience, let me share this. Someone who has one DUI is typically not going to be qualified because it's not going to disqualify them from getting a visa. Same with 2 DUIs. Once you get to a 3rd DUI, you might run into disqualification based on discretion, where the government can say, well, now we don't want you to be here because we think you don't have good moral character because now you've got 3 DUIs and you've got something, right? Where technically the law itself wouldn't disqualify them, but based on immigration's discretion, they could say you don't have good moral character now. Another thing could be if you're found guilty of an aggravated felony, that can prevent you from obtaining a visa, because if there's no waiver for it, you're going to be inadmissible, right? Another one, let's give you a clear-cut example. If you have a conviction that has to do with drug trafficking, selling, maintaining a drug house, possession with intent to distribute or actually distributing, those will be disqualifying criminal history things that will prevent you from getting a visa, and apparently under this program from getting this temporary parole. So there's still a little bit of vagary in this. I feel comfortable saying that simple things like disturbing the peace, things that come out as a civil infraction, misdemeanors that don't have to do with trafficking drugs or crimes of violence or domestic violence, should be all right. Any criminal history, though, I am going to tell you right now, find an attorney when you can actually file applications for this. Get an experienced immigration attorney who can run you through an analysis and help you with that. And of course, if you're a threat to national security or public safety, I'm sorry, no, you don't qualify, and you probably shouldn't. Let's also talk about the children now, right? So non-citizen children of spouses who get this parole can also get parole on a case-by-case basis if they're physically present in the United States without admission or parole, and they have a qualifying stepchild relationship with the U.S. citizen parent. Briefly, that means that the step-parent was married to their parent before the child was 18 years old, and they had some sort of a parental relationship as well. That's how you can qualify as a stepchild under immigration law. It says here there's going to be a form you'll need to file. There's going to be a fee. Now, all of those details are still forthcoming. They need to follow a process to do this correctly so it doesn't get overturned by a court or a judge later. So they're going to be publishing that information in the Federal Register. There will be a period of public comment. They will take those public comments into consideration, possibly make modifications or adjustments, and then they will publish the final rule. And then a certain amount of time after the final rule is published, they'll be able to start accepting applications. They've not said what form to file. They've not said how much it will cost. In fact, in the questions below, they say, don't file anything or we'll just deny the request. Okay, here's a disclaimer that even immigration provides. Don't become a victim of a scam. Like I'm telling you right now, it's not time to pay an attorney to do this. It's not ever advisable to go to a notary. They lack experience, knowledge, and the legal license to do some of the things that we know they do, right? There's going to be scams. There'll be government impersonators. If you get a call from someone saying, oh, this is USCIS, looks like you're eligible for this. It's a lie. USCIS, look, you call the 800 number to get help. They barely answer the phone. They're certainly not going to be making phone calls to people who are potentially eligible. Scam websites, yes, be careful. Just find an attorney. Payments by phone or email. Government is not going to do that. They don't do that, so please don't send money to a scam. Public notaries and unauthorized practitioners of immigration law, please don't use them. A notary public is not authorized to provide any legal services or legal advice. That includes helping you choose which forms or telling if you're eligible. They didn't go to law school. They don't have experience with this stuff. And they've done more harm than good in the past. So stay away from them. I'm sure there's going to be plenty of immigration attorneys who, for a fair fee and an ethical fee, will be able to help you out. Hopefully we'll be one of those for you. Here's some key questions that they provided. When will the process start? Again, after they follow the legal process to announce it, etc. What happens if you apply beforehand? They're going to reject it, and they may just keep all the money that you send. So don't do that. What will be the duration of parole? Okay, here we get an actual answer. The period of parole is going to be for 3 years. It's plenty of time to file an application for adjustment of status and to have it approved. You should only need to file one time. And at the conclusion of here's what they say. At the conclusion of the parole period, USCIS anticipates you'll have either a pending adjustment or final adjustment completed. Now, to me, this is code. This is immigration code for, we anticipate you'll have this. What they're not saying is, however, if you don't, we'll renew it for you. I think there's a high possibility that there will be the possibility to extend it or apply for a second time if there's some extenuating circumstance that made it impossible for you to get your status earlier through adjustment of status with a family petition. That's me, theorizing at this point, but they worded it very carefully, and I think that's why. Application process. What can I do now to prepare? Okay, finally, some helpful advice. Start gathering documentation that you've been here for 10 years. Now, the magic question is, what would those documents be? And the real answer is pretty much anything that's real, pretty much anything that tends to show you've been here. This could be bank statements, credit card statements, medical bills, school records, church records. If you've served or volunteered, any of those records would be helpful. Water bill, gas bill, light bill, cell phone bill, driver's license records, employment records. All of these things can be helpful, okay? But it needs to be something that shows you were here in the United States. If you're going to rely only on affidavits, your case may be harder and may not be approved. If you're just getting your friends to write a letter for you saying, oh, I promise he did this, I'll tell you that with DACA, that wasn't usually enough, unless there was nothing else and you had very convincing evidence. So I'm going to say don't rely on that. Rely on actual documentation that you still can gather. I know 10 years seems like a long time, but I'll tell you, if you have a driving record, you can go to the Secretary of State and they can print it off for you. If you have a credit history, you can print that off. That's great. A bank statement history, you can go to the bank and request. I mean, depending on your bank, they may go back a number of years, maybe up to 10. So those are some things that you can look at as well. Evidence of a legally valid marriage to a U.S. citizen as of June 17, 2024. Now, to me, this says you were married on June 17th by, we're in the status of married on June 17, 2024. It's still, I guess you could make an argument that it's ambiguous. So if there's any hope, like if you had been married and then got divorced, so on June 17th, you were divorced from a U.S. citizen, I'm going to say let's still look at some options. You may qualify for something called the Violence Against Women's Act, which applies to men and women and those who don't identify as either, I guess. If you were subject to extreme cruelty or domestic violence. So even if it never came to actual physical violence, but you were subject to extreme cruelty, like somebody told you you're worthless, you don't serve for anything, you just have to do these things I say, or I'm going to call ICE on you. We may have a VAWA case that we can do for you. But typically the evidence of a legally valid marriage is going to be your marriage certificate. If it's not from the US, well, it sure should be. Otherwise, it means you haven't been here during the last 10 years. Now, I guess technically it could mean that you were married before the 10 years in a different country and then entered, and the person you married was or is now a U.S. citizen. So in a situation where maybe you have a spouse who was a resident but became a citizen by June 17th, you're going to want copies of their records, the citizenship certificate. That's going to help in conjunction with your marriage certificate. Translation, if it's not in English. Evidence of favorable discretionary factors that the applicant would like USCIS to consider. Okay, and here's where you can have a lot of fun. Here's where you can bring in affidavits from friends and family talking about how great you are. Other positive factors could just be an absence of a criminal record. Could be proof that you served with a religious or charitable organization, that you're an asset to the community, you're doing good things for the community. It could be a number of those things. So any information that shows you're a good person. And I know that for a lot of people who come to meet with me, once we get past the overall eligibility part, they always like to share that. So that can be something that's helpful for immigration and making a decision on the case as well. Will you need to submit biometrics? Yeah, there's going to be fingerprints in this process. And that's just because they're going to do a security check and make sure you're eligible for the benefit you're applying for. In our office, we actually have a fingerprint scanner, and we have the ability to do a fingerprint check for you with the FBI. So if you're in doubt about your criminal history or your arrest history or the history of getting stopped at the border, that's a service we can provide to you. Of course, there's a fee associated with it, but you don't have to go to a police department, and we can definitely help. Will the parole application be available online, on paper, or both? It just says, hey, we'll give you more instructions. So probably yes to the above. What is the fee? Again, they're going to tell you in the future what the fee will be. Can the fee be waived? They're going to publish information in the Federal Register about that. Typically, there is a fee waiver process if you can demonstrate that you are below the poverty level for income, but we'll have to see. Now, for people who entered with a visa, you're not going to benefit from this parole program. And the reason for that is simple. It's because you already have eligibility to adjust your status here if you meet all the other requirements, right? There's under 245, under INA 245A, someone who enters the U.S. lawfully and now has someone who can petition for them, so a 21-year-old child or a U.S. citizen spouse, they're allowed to already file the adjustment paperwork here in the United States. Now, what about if you're in removal proceedings? This is an excellent question. If you're in removal proceedings, you may still apply for parole under this process. USCIS is going to take a closer look at it. They're going to look at why you're in immigration proceedings. You know, many of the sympathetic cases where really someone is not a danger to the public, a lot of those cases have been closed already. So if your case is still open, they're going to be looking at that to figure out if they want to use their discretion to grant it. So if you're not a priority for removal, right? You're not a terrorist. You don't have a huge history of entering and leaving the country or breaking immigration law. There's the possibility that it can be approved. And if your parole request is pending and you're encountered by Border Patrol or ICE, will you be placed into removal proceedings? Again, you know, they have guidelines already for who to place in removal proceedings. So could be yes. You still could be subject to that. If you're not a priority for removal, could be that they don't ever put you in removal proceedings. It's going to depend on the circumstances. And what happens if you apply for parole once they eventually tell us how, when and where, and how much? If they deny your application for parole, will you be placed in removal proceedings? USCIS already has this ability to do that, and they may. But it's typically reserved for drug traffickers, people who are, you know, they got just an awful criminal history or have been or are a danger to the public or to national security. So those will be considerations when you initially file. If that describes you, you're clearly not eligible, and you, well, you know, from my perspective, go ahead and do it. You probably are not going to be happy with the results, but the rest of us might be. Talk to an attorney first. If you have a criminal history, can you apply for parole under this process? Sure you can, but you're definitely going to want to talk to an attorney to see if you're going to be eligible or not, and to weigh your options and to weigh the risks and benefits. Okay. Disqualifying criminal history includes criminal convictions that are likely to render the individual statutorily ineligible for adjustment of status, as well as convictions that do not render non-citizens statutorily ineligible for adjustment of status, but nevertheless warrant their disqualification from this process in the exercise of discretion. And they'll be giving more guidance on that in the future. So stay tuned for more information on that. We'll do an update video when it comes out. And again, it's just redefining it here that children of non-citizen spouses covered by this policy will also be able to qualify based on having a step-parent relationship. So single, under 21, and can still qualify based on that step-parent relationship, as we discussed earlier. And again, you know, can you apply for a work permit at the same time? They're going to give instructions on that. That's forthcoming. How long will it take to receive a decision? You have to kind of laugh when you read this because it just says processing times vary. We have several tools you can use to check your status, including this tool, but there's no promise. And I can tell you they probably are not going to put a promise there, because if they do, then later we attorneys can sue them and say, hey, they said it was going to take this long and now it's taking longer. So I think their lawyers on their side were probably considering that when they were giving this announcement. But let's have faith. Let's be hopeful. Let's be optimistic. This is actually a pretty great benefit for people who are married to U.S. citizens in order to make these petitions go more quickly. We'll release another video going into detail as to why, this really isn't immigration reform. This is not a major change in the law. It's not like President Biden is just doing something on his own on a whim, trying to skip the Congress, because this is authority that already exists in the presidency. We'll go into detail on another video, but I wanted to share this update with you. And again, for those who don't know, my name is Attorney James Betzold. I have 15 years of experience as an immigration attorney, serving clients in the state of Michigan and throughout the United States and the world. We've helped unite thousands of families through immigration. So we're pretty excited about this new program that's going to be capable of helping unite even more. All right. I hope you all have a great day. Reach out with any questions or if you want to schedule a consultation. Again, it's not time to file these applications. However, if you would like to share your information with us, we'll be happy to keep it on file and give you updates throughout the process. All right. Take care.